Mr. Summerstein, you prepared an opinion in this case,
I did.
and specifically you prepared a report.
Yes, I did.
And one of your opinions in that report was that the plaintiff was not trespassing on June 6, 2015.
I don't believe that he was, no.
And based on that, you based that opinion on the fact that the plaintiff was never asked to leave the property.
That's correct.
Now you know that Mr. Simon's ice cream parlor closes at 10 p.m.
I believe that it did close that night at 10 p.m.
Your Honor, permission to read a stipulation to the jury. On Saturday, June 6, 2015, defendant's business was open from the hours of 12 o'clock p.m. until 10 o'clock p.m. So again, Mr. Summerstein, you agree that on June 6th, the shop was open until 10 p.m.?
Well, you just read it.
Okay. You reviewed a number of depositions in preparation for today,
I did.
and one of those depositions was Christy Folotanova.
That's correct.
And she was an employee at Mr. Simon's ice cream parlor, correct?
The only one, yes.
You reviewed her deposition in its entirety,
I did.
and you know she was the only employee, as you indicated, there at 10 p.m.?
That's correct.
In that deposition, you know Ms. Folotanova told the plaintiff to leave the property around 2 or 3 times?
I believe that's what she says, yes.
Yet, in your opinion, you indicated that the plaintiff was not trespassing because he was a customer?
Well, he was a customer, and her English isn't very good, so I took what he said and all the circumstances that indicated that it was more likely that he wasn't actually asked to leave.
Mr. Summerstein, as a former officer, you took statements from witnesses or victims in any given crime, correct?
Sure.
At times, you can get conflicting statements from a witness or a victim,
Sometimes.
and you had to weigh the credibility of those statements.
Yes.
I'd like to talk about the security system Mr. Simon had set up at Scooter's ice cream shop. Let's first discuss the lights.
Okay.
Mr. Summerstein, you can see these 6 circles here,
I can.
and they're marked with the letter L
That's
inside the
correct.
circles. And those indicate the lights on Mr. Simon's property.
That's what the key says, yes.
And you know those lights were on at 10 o'clock p.m. on June 6th.
My review of the record indicates that they were likely off, yes.
Oh. You know right after the attack that occurred on the plaintiff, the police arrived on the scene.
That's correct.
You know the officers wrote a report.
That's correct.
Your Honor, permission to approach the witness. I am handing you, Mr. Summerstein, the police report from June 6, 2015. You recognize that document, right?
Yes.
Your Honor, the defense offers this into evidence as trial exhibit 2. It has been stipulated authentic. Mr. Summerstein, in that report describes the lighting at the scene.
It does.
It indicates that officers arrived to a well-lit scene.
A well-lit area, yes.
It also mentions a sidewalk.
It does.
It mentions the sidewalk is also well-lit.
It only says that there's sufficient ambient light.
So it explicitly states in the police report that there is ambient light, correct? Your Honor, permission to retrieve the document from the witness. Mr. Summerstein, now I'd like to talk about the cameras. This map indicates that there are 2 cameras right here.
That's correct.
And you know that the point of these cameras is to serve a deterrent effect.
That's the point of cameras, yes.
So if cameras are visible, it is less likely for a crime to take place.
Yes.
And again, there's 2 maps here, 2 cameras here, and these are located outside, correct?
Outside of...
Outside of Mr. Simon's ice cream parlor.
That's correct.
And they're marked by the letter C.
Yes.
And both of these cameras face the parking lot.
That's correct.
You know that the employee, again, you reviewed Ms. Filotanova's deposition,
That's correct.
and you know that she marked where the plaintiff was standing.
Standing when?
At the time of the attack.
She does indicate where she told the plaintiff to go.
And she did that by marking her initials right here?
That's correct.
Now, I'd like to talk to you a little bit about the plaintiff's action prior to his attack. You spoke in your opinion about security of a business,
Yes,
and again, you were a former police officer yourself,
that's correct.
and you know that people have a responsibility to watch out for their own safety.
To an extent,
You reviewed the deposition of the plaintiff.
I did.
You were here in the courtroom today when the plaintiff was testifying.
Yes, I was.
The plaintiff was attacked at 10:45 p.m., is that right?
I believe so, roughly.
And you know that he indicated he was standing on the sidewalk.
Yes,
He was standing with a few of his friends.
yes.
You know one of his friends told him that someone was coming.
When?
The point before he was attacked, his friends indicated that someone was coming.
That's correct.
And the friends suggested that they should all leave.
I believe so.
And you know from your review that the plaintiff did not in fact leave.
Yes,
You know that the assailant said something to him too.
yes.
And the plaintiff still did not leave. Is that right?
No, the plaintiff was immediately attacked upon hearing something to the effect that the assailant knew he would find.
Right. So then he was attacked, and you were aware that his friends were able to run away.
Yes.
But the plaintiff was not able to.
No, it appears that he was the first one to be attacked.
No further questions.
Jesus.
So,
Let's go.
the lead up in the policeman section, you were a policeman, you've taken interviews before. That all has to come before the discussion of the differences between the two testimonies.
Wait, say that again. When I did with the first point.
Yeah. So when you talk about you were a policeman, you've done interviews before. That all has to come before you do the comparison of the two interviews. So one thing to consider is always do theory before fact.
Wait, what two interviews are you talking about?
The two depositions, plaintiff's deposition, Fultonova's deposition.
Oh,
and the
okay.
inconsistencies between the two.
Right.
Always do theory first. In cross-examination, do theory first. So it's, and be more, you jumbled a lot of the information all at once. You were formerly a police officer. You were in the homicide division. You received distinction. As part of the homicide division, you must have conducted interviews before, right? You've conducted interviews with victims, right? You've conducted interviews with eyewitnesses, right? Now, you know that sometimes interviews can conflict about the same event, right? And perhaps sometimes you have to give more weight to an objective eyewitness than you would necessarily to somebody who has an interest in the outcome of a case, right? Right. All of those questions, lots of questions.
So put that up
Before.
top.
Then you go into, now, you reviewed the plaintiff's deposition. He says, because what do you go into?
I just don't know where you.
Let me
All
see.
right, because I
Let
did
me see.
the two different depositions at different times.
No.
Right, then they talked about Christy.
Then you reviewed depositions. One of those depositions is Christy Fultonova. She was an employee, and so blah, blah, blah. And yeah, so all of this goes before,
Okay.
all right? So you know the store closes at 10 p.m.,
Okay.
all right? And then you'll say, you were officer. This is more questions, more than just this. You were an officer. You were in the homicide division. You must have conducted interviews. Each one of those is an individual fact.
Okay.
And then you'll say, now the plaintiff has testified that he was told to go to the sidewalk, right? Now, you reviewed the deposition of Christy Fultonova. Fultonova was an employee, and then you go through everything.
Okay.
But this sets that up. So now you're telling us that the conflict of the fact is between the plaintiff and Ms. Fultonova. But you've established through the theory aspect of it the foundational aspect of it, that perhaps sometimes an objective third party is more reliable than someone who has an interest in the outcome of the case.
Okay. I like that.
All right? But do that first. Because if you do it afterwards, then they know why you're doing it. Well, they're going to know why you're doing it anyway. But it's better to do that before with the jury. So that way when we go through the 2 depositions, we understand why you're doing that. Okay?
Okay, I like that, that's good.
The other thing is the police report. So the police report, using it is fine, but you need to be more descriptive. And let me see it really quick, so I can explain what I mean. So here's the police report. Now there are a number of headers here. I'd like you to turn your attention to the header that says description of the scene. Now, in description of the scene, it says this officer arrived to a well-lit area, right? Right. And then it says on the 3rd sentence, the sidewalk area outside of scooters had sufficient ambient light, right? Right. You want to be very specific about where to turn their attention. So instead of saying it talks about the lighting, just turn their attention exactly where you want them to look.
Okay.
Because remember, you're giving everyone a copy. So you want them to be looking too. So if you say turn to description of the scene, they'll go there too. And then if you say the first sentence, it says this officer arrived to a well-lit area, right? Right. And then the 3rd sentence. The 3rd sentence says this, right? Right.
Okay, cool.
And then you don't ask the conclusion. So it was well lit. Don't ask that.
Next
Does that
victim.
make sense?
No, I like